Got two people on the stage.
Glad to see you all here this morning. All right. Joint resolution relative to the decision of the United States Supreme Court reversing decision of the Supreme Court of Wisconsin. Whereas the Supreme Court of the United States has assumed appellate jurisdiction in the matter of the petition of Sherman M. Booth for a writ of habeas corpus presented and prosecuted to final judgment in the Supreme Court of this state, and has, without process or any of the forms recognized by law, assumed the power to reverse that judgment in a matter involving the personal liberty of the citizen, asserted by and adjusted to him by the regular course of judicial proceedings upon the great writ of liberty secured to the people of each state by the Constitution of the United States. And whereas such assumption of power and authority by the Supreme Court of the United States to become the final arbiter of the liberty of the citizen and to override and nullify the judgments of the state courts, declaration thereof, is in direct conflict with that provision of the Constitution of the United States which secures to the people the benefits of writ of habeas corpus. Therefore, resolved, the Senate concurring, that we regard the action of the Supreme Court of the United States in assuming jurisdiction in the case before mentioned as an arbitrary act of power, unauthorized by the Constitution, and virtually superseding the benefit of the writ of habeas corpus, and prostrating the rights and liberties of the people at the foot of unlimited power. Resolved, that this assumption of a jurisdiction by the federal judiciary in the said case and without process is an act of undelegated power and therefore without authority, void, and of no force.
That's right.
Resolved, that the government formed by the Constitution of the United States was not made the exclusive or final judge of the extent of the powers delegated to itself, but that in all other cases of compact among parties having no common judge, each party has an equal right to judge for itself as well of infractions as of the mode and measure of redress. Resolved, that the principle and construction contended for by the party which now rules in the councils of the nation and the general government is the exclusive judge of the extent of the powers delegated to it. Stop nothing short of despotism, since the discretion of those who administer the government and not the Constitution would be the measure of their powers. That the several states which formed that instrument, being sovereign and independent, have the unquestionable right to judge of its infraction, and that a positive defiance of those sovereignties of all unauthorized acts done or attempted to be done under color of that instrument is the rightful remedy. Approved March 1859.
Wow.